A very good morning to Madam and all my fellow friends. So, my name is Ong Jenny, metric number 288958, and my pairmates Tan Ro Yin, metric number 289244. So, today we would like to have a presentation together with a topic of media law, Sedition Act, Malaysian Sedition Act 1948. So, here we go. So I would like to start with the introduction of Seduction Act 1948. Seduction Act is a law prohibiting discourses deemed as seditious. The act was originally enacted by the colonial authorities of British Malaya in 1948 to contain the local communist insurgents. So the act criminally speech with seditious tendency, including that which would bring into hatred or contempt or to excite defa- disaffection against the government or engenders feeling of ill will and hostility between different races. The meaning of seditious tendency is defined in Section 3 of the Sedition Act 1948 and in substance it is similar to the English common law definition of seditious, which modification to suit local circumstances. The Malaysian definition includes the questioning of certain portions of the Constitution of Malaysia, namely those pertaining to the Malaysia social contract, such as Article 153, which deal with special right for the Bumi Putra, and sedition as an offence came into existence in Malaysia during the British colonial era. The crime of sedition has its root in an era when statesmen and political leaders were considered to be largest above reproach by the common man, and when the institutions of government were far more precious than at present. Coup and revolution were a constant threat, and the resort to political violence a common phenomenon. Sedition as a concept is largest antithetical to the underlying premise of modern democracy. As a result, sedition laws in many countries have either been repealed or have fallen into disuse for some time. Against this backdrop, it is surprisingly to find that prosecutions for sedition are becoming increasingly common in Malaysia. So I will moving on to the history of the Seduction Act. Seduction Act. This law was introduced by the British in 1948, the same year that the Autonomous Federation of Malaya came into being, with the mean of curbing opposition to colonial rules. So the law remained on the stated boot through independence in 1957 and the merger with Sabah, Sarawak, and Singapore that formed Malaysia. After May 13 incident, when racial riots in the capital of Kuala Lumpur led to at least 200 deaths, the government amended the constitution to expand the scope of limitation on freedom of speech. These later amendments were harshly criticized by the opposition parties in parliament, who had campaigned for greater political equality for non-Malaya in the 1969 general election. There has been several challenges to the constitutionality of the Seduction Act. In 2016, Malaysia Court of Appeal ruled that the section of the Act which states that the intention of a person charged under the Act is irrelevant was unconstitutional. So, human rights groups accused the governing Barisan Nasional coalition of expanding the scope of the law since it gained independence from the British 5 decades ago. They say that the definition is now too vague, and nowadays the law bans any act, speech, or publication that bring contempt against the government or Malaysia Nine Royal Sultan. It also prohibits people from inciting hatred between different races and religions or questioning the special position of the ethnic Malay majority of the native of Sabah and Sarawak.
Good morning, doctor. My name is Sarah Ying and my metric number is 289244. I will continue by defining the purpose of Sedition Act. The law defines sedition as anything that when applied or used in the respect of any act, speech, words, publications or other thing qualifies the act, speech, words, publications or another thing which as having a seditious tendency. So, how to depends whether the incidents having a seditious tendency or not is by when the incidents provokes hatred or contempt for or stirs up oppositions to the ruler or government, as well as when it encourages the populace to change any legal provisions in a way which is illegal. Moreover, the incident which is also provokes negative emotions towards how justice is handled in these nations too. When it incites animosity towards other people and encourages animosity and hatred between racial groups, this defines the purpose of the Seditions Act. When there is happening of the questions between privileges, rights, and sovereignty of the rulers, as well as a number of constitutional articles, including those relating to citizenship, the use of the official language and other languages, the special privilege according to the Malays, and the sovereignty of the government. This act is used as the ruler to determine the seriousness of the incidents. However, Sedition Act also offers exemptions. A piece of writing is not considered as seditious if it is distributed to when the condition as in demonstrating any instances in which a ruler's decisions or actions were erroneous or misleading. It is also distributed when it is pointing out the shortcomings of the government, the constitutions, the law, or the administrations of justice with the intentions of fixing the deficiencies. Lastly, when it is distributed to encouraging the populace to change any legal requirements by using legal means. Meanwhile, when it is also identifying and addressing any issues that foster animosity and hostility between groups of people and races. However, the Act explicitly states that any matter covered by the subsections 1, 5F, namely those matters pertaining to the Malaysian social contract, cannot have these exceptions applied to it. Furthermore, in Seditions Act of Section 33, it is about when any person who is found guilty of writing, printing, or publishing, selling, offering for sale, distributing, importing, or selling publications with such seditious tendency shall be imprisoned for a term not exceeding 3 years or fined not exceeding 5,000 ringgit or both for the first offence. For the subsequent offences, he may be imprisoned for a term not exceeding 5 years, and the publication shall be seized and destroyed. Continuing with the offences element of Sedition Act, which is under the Sections 4 of Sedition Act. It specifies that anyone who does or attempts to do or makes any preparations to do or conspires with any person to do an act with seditious tendency, such as uttering seditious words or printing, publishing, or importing seditious literature, is guilty of sedition. It is also a crime to possess a seditious publications without a lawful excuse. The Act defines sedition itself as anything which, when applied or used in respect of any act, speech, words, publications, or other thing qualifies the act, speech, words, publications, or other thing as having a seditious tendency, which is same as the purpose mentioned before. First of all, any person who commits, attempts to commit, make preparations for, or conspires with another person to commit any act that has or that, if committed, would have a tendency towards seditiousness, utters any words that are seditious, prints, publishes, sells, offers for sale, distributes, or replicates any publication that is seditious, and also imports any publication that is seditious is all about the elements which may offense against the Sedition Act. Secondly, person who without lawful excuse, which has in his possessions with any seditious publication, shall be guilty of an offence, and shall on convictions, and also be liable for a first offence to a fine which is not exceeding 2,000 ringgit or to imprisonment for 18 months or both, while for a subsequent offence to imprisonment for a term not exceeding 3 years, and the publication shall be forfeited and may be destroyed. If a person receives the seditious publications without his knowledge, he should prove to the court with regard to the actual situations.
So, for the example of related cases of seduction act, one of the cases is about the Iswardi Moni disiasat bawa Akta Hasutan 1948. It is all about the related cases about Police Diraja Malaysia has detained the owner of the Facebook account Iswardi Moni, who is believed to have released a statement that Persenda and resounded Yang di-Pertuan Agong Al-Sultan Abdullah Riyatuddin Al-Mustafa Billah Shah, Menteri Dalam Negeri. Datuk Sri Hamzah Zainuddin said that the detention was made pursuant to the provision of Section 8(2) and Section 11 Akta under Akta Hasutan 1948, which means Section 8 Act 194, Seduction Act 1948. According to him, Jabatan Siasatan Jenayah PDRM is also investigating the individual under Section 504 Kanun Keseksaan and the Communication and Multimedia Act 1998. The unpatriotic and irresponsible act is one jenayah that can cause public distress, he said in a statement today. Iswardi Moni, who is also Pengerusi Pro Keadilan Sarawak, released a statement through a live video on the official YouTube page, charged with incitement and insulting the Yang di-Pertuan Agong. He was also charged with uploading a video titled Total Lockdown, What the Kingdom Failed to Learn in a Year. And this live video also received up to 38,645,000 views. So, the second related cases of Sedition Act is in July 29 in Kuala Lumpur. An activist who is part of the Lawan campaign has been arrested today for investigation under Section 4(1) of the Sedition Act 1948 while giving Sarah's statement at the Dangwangi police. The SSR has previously claimed that the police had also harassed Sarah's family when calling her into questioning today. And meanwhile, Sarah's lawyer Goh Jia-yi said that police are planning to detain her overnight at the police station, and they had arrested her now with the intention to detain her overnight, and her house had not been raided yet, and there is no confirmation on when they would like to do this. So they intend to do so, but the timeline of this is uncertain at the moment because they have some paperwork to sort out. And Section 4(1) handle act with seditious tendency, which include altering seditious word and distributing. If found guilty, one is liable to a fine not exceeding 5,000 or prison not more than 3 years or both. So, in a brief statement on social media, Missy Solidarity has also demanded the authority to release Sarah immediately. So, seeing one of them be silent and harassed by the authority in inferiority, they stand in complete solidarity with Sarah and they demand her immediately release. It also urged netizens to show solidarity and support to Sarah by using the hashtag such as hashtag Free Sarah, hashtag activists are not criminal, and hashtag Lawan Intimidasi in their social media posts. So, that's all for the related cases, and I would like to pass to my pairmate.
Last but not least, to evaluate the relevancy of the media law in the current situations, we can conclude that Sedition Act is still relevant to the situation in Malaysia, as the purpose of maintaining the security and stability of our country. However, there is enhancements needed for the Act, such as the enforcement of the punishment, in order to strengthen the law. Hence, Sedition Act has to be reserved and practiced among the community in order to make sure the safety of the life. That's all from us.